Hello and welcome to Let the Record Show. I'm Todd Sivia, your host and partner in navigating life's transitions. At Sivia Law, we believe that every transition in life deserves careful consideration and planning, and that's exactly what we're here to help you with. In each episode of our radio production, we tackle important topics that can impact your life, your family, and your future. From estate planning to real estate, from business succession to elder law, we aim to provide you with valuable insights and expert advice. We'll explore a diverse range of topics and invite expert guests to share their insights and wisdom. Our mission is to improve you with the knowledge and resources you need to make well-informed decisions, no matter what stage of life you're in. Let me remind you that the information shared during this show is for general education purposes only and should not be considered legal advice. Every situation is unique. We always recommend consulting with a qualified professional to address your specific circumstances. Just remember, the choice of a lawyer is an important decision and should not be based upon advertisement. Today, we're going to be diving into the fascinating world of estate planning established by the state legislature, exploring its significance and impact, and how it relates to your life. As we embark on this journey together, I encourage you to stay engaged, take notes if needed, and should you have any questions or thoughts during the show, feel free to reach out to us by calling us at 618-217-1400. Again, the phone number is 618-217-1400. Or you can email us at radio@sivialaw.com. Again, it's radio@SI, as in Victor, IA law.com. Thank you once again for joining us. We are committed to being your trusted resource as you navigate the intricacies of life's transitions. Sit back, relax. Let's explore estate planning together. Let the record show that we are here to guide you in every step of the way. Let's get to it. Today, we're talking about wills. Well, actually, estate planning. I don't know if you know it or not, but everybody has an estate plan, and you may not like it, but our wonderful people up there in Springfield, Illinois, or Jefferson City, if you're listening from the Missouri side, have a plan for you. And they have written your estate plan for you based upon the state statutes. I don't like politicians telling me what my estate plan should be. And there's some doozies in there for those that have not set up a plan or haven't established a plan. You know, again, the state legislators has set it out for you. And if you don't write it or have a will or a trust or any kind of estate plan established, well, the state legislature has set that up for you. So let's talk about that. If you want to read about, a will and see the will specifically, you can go onto our website at sivialaw.com and click on the resources tab and look for the John Doe will. There's a John Doe will that is established and set up, and we wrote the will based upon the state's legislator. We're going to go through it today, but if you want to read through it, you're welcome to go to our website. Again, click on that resources tab, look for the John Doe will. We have an Illinois and Missouri will that is established. So what does it look like? The most important thing, and this is kind of the shocking one, your assets are not given to your spouse 100%. They're actually given to your children. Half it goes to your children, half goes to your spouse. I had a client several years ago, and they were delaying the estate planning process. And spouse had inherited a piece of real estate into their name. And at that point in time, they were looking to do some kind of estate plan, and they delayed it. Gal ended up passing away, and she was required to go through probate. Because she had no will whatsoever, her husband was able to inherit half of the piece of real estate, and her two kids inherited the other half. So before, she had her funeral established and taken care of. So there was no funeral bills, but all those expenses, and we ended up having to go through probate. And in that estate, there was charges that were required based upon the probate process. And instead of going through and have a pre-established plan, we had to go through the probate process. So half of your assets, based upon the state legislator, half of your assets go to your spouse, the other half goes to your children. And there's no controls. And, if the child is not the most responsible person, we are stuck with handing that asset over to the children. I don't know about you, but usually people that I talk to, they want to take care of their spouse first and then hand it over to the children. In this case, we were not able to do so. A lot of people don't realize this, but the state legislature requires that you post a bond. For example, in the case that we talked about, the bond, the husband was required to go get a bond to ensure that he was not going to steal his wife's estate's money. And he had to pay a insurance policy, and that's what a bond is an insurance policy that sets up and establishes that to ensure that the person is not going to steal the money. Lately, what we've found is judges are really concerned about that and don't want estates to, if there's no provision within the will providing for a bond, they're going to require a bond. They're going to require that you go get an insurance policy that insures it. Well, depending upon the circumstances, your creditors or your children, maybe they're 25, maybe they're 23, or in their early 30s, and they just bought a house, or they're going through some tough times, and maybe they don't have the best credit rating. Maybe they have a 620 credit score. They're not going to be able to get a bond. They're not going to be able to get this insurance policy to ensure that this person is able to do so. Or the rates would be so high that it becomes financially unreasonable for them to participate, and they'll have to go find somebody else to be the executor of their estate. But, that's based upon the law. The law requires, these bonds to be posted. So how much could it be? I mean, it could be anywhere in the range of $5,000 to $10,000. So you're going to pay a bond of $5,000 to $10,000 to ensure that your spouse is not going to steal your money, or your kids are not going to steal the money. That's a huge requirement. There's also requirements for them to account. They have to do a physical accounting. What does that mean? They have to draft up an account and figure out how much money that they have and how much they spent on this, that, or the other. So did they spend money on clothing for the funeral? Did they spend money for flowers? Did they spend money on the tombstone or anything like that? And because it's an accounting and it's a requirement based upon the statute, that gives the opportunity of any beneficiary to dispute that accounting. Maybe they spent something that the administrator in this circumstance could be your spouse. Your spouse has to account to your children on what they spent the money on. Was it reasonable or was it not? And those are all expenses and things that has to be completed. Well, if you have to get into a detailed accounting, that adds to the cost of probate. It requires either a bookkeeper to put this together. It may require a paralegal to put it together. It may require the person to spend a lot of time and energy on putting something together? Well, it's mandated per the statute if you don't have a will on how that happens. So that's going to be a requirement. Also, there is no requirement as of the person to once they turn age 18. Say husband passes away, wife is in charge of the probate estate, and at age 18, the two children, say Ben and Anna as your kids' names, and Ben and Anna are maybe they're 14 years old at that point in time when dad passes away. And after that, as soon as they turn age 18, they are mandated to receive their inheritance, whatever the inheritance is. There's no restrictions. And if there's $100,000, $200,000 in assets that were to be handed over to that child, because half of the assets went to that child, at age 18, if they want to buy a Lamborghini, they can buy the Lamborghini. There's no restrictions. As of age 18, they are responsible under the law to continue and allow them to have as much resources as they want. It's important for us to protect that. Following the state legislators' rules, they believe that anybody over the age of 18 is financially responsible for anything that they have. Yeah, so if you're buying a Lamborghini and you're age 18 and you want the child to go to school, or if you want the child to be responsible, and if we're trying to extend some kind of value to that 18-year-old, unfortunately, that distribution will be required to be distributed to that individual at age 18. So it's important for you to know whether it's grandchildren or children, they're not financially astute at age 18. Because, where I was at age 18, I was pretty responsible at age 18. But if I got hit with a whole bunch of money, I don't think that I would have the financial capability that I would today at age 18 to be able to manage a large sum of money. Based upon the state statutes, there is no control. There's no control. If we look at from experience, if we look at statistics really give us an indication of how responsible people are. Most people, even whether they are age 18 or anything else like that, most people that receive either inheritance or receive money from the lottery, most individuals, if they receive money from the lottery, within 5 to 6 years, if you catch this, within 5 to 6 years, they file bankruptcy. So within a very short period of time, the money that they receive through the lottery or through their inheritance is gone in a very, very short order. If there's a mandate for outright distributions, that could be a problem. If you don't have a plan, the plan is definitely set out for you. So, key thing with regards to age 18 that a lot of people don't realize, and I want to touch on this point because we're talking about 18-year-olds. If you got a child that is getting ready to go to college, it's August, and it's August the 5th, and people are getting ready to go to college or getting ready to move out of their house, and they've turned age 18. What is going to happen? A lot of people say, oh, well, that child at age 18, I can make financial decisions still for that child. I can make healthcare decisions for that child. Unfortunately, that is not the case. As of age 18, that individual turns age 18 and their parents are not financially or have any kind of financial or healthcare decision-making capacity at all. And doctors are not required to give you any information with regards to that individual as of age 18. So if you're looking to give a gift of anything for for a grandchild or a child that just turned age 18, a great gift right now would be get them a power of attorney for their financial and healthcare decision making. So it's very, very important for people, even as of the age of 18, to have some kind of healthcare decision or power of attorneys, living wills, and things of that sort. There was a key case many years ago, kind of going on that subject. There was a key case called Terry Schiavo. When I was going through law school, it was a pretty big case, and a lot of people were talking about it. Terry had just gotten married and really new relationship with her husband, and her parents wanted to have a say-so in her healthcare decision because she was declared to be brain dead. And there was a big fight between husband and parents that went all the way to the U.S. Supreme Court to have this discussion over who has the financial or healthcare decision-making process, the parents or the husband, and what were the terms. Husband wanted to let wife go. Parents wanted to maintain that child and make sure that that child continued to live it with all means necessary. And the child, Terry, continued to live with a feeding tube to keep her alive. But that's the rules and discussions and litigation that related to poor Terry and the individual fights between the family. It's important to, as of age 18, set out what the guidelines are for your will, your power of attorneys, and the like. One other issue that most people don't think about that the state statute has established. What if that child had any kind of special needs? If that child that was under the age of 18 inherited, well, under the rules based upon state statutes, that money would still be given to that child. The person may have Down syndrome, they may have cerebral palsy, they may have some kind of traumatic brain injury, and even though their parent has passed away and they received half of the estate based upon the state statute, that money goes to that special needs child. Now, not only do you have to open up a probate estate, but you now have to set up a guardianship and deal with guardianship matters and figure out how do we handle that dichotomy during those circumstances. And it's very important for us to know, how to handle those issues. But what does that mean? Okay, so person has resources. So they received $100,000 to $200,000 and they didn't have an estate plan. So there was no special needs trust. There's no protections associated with that individual. That individual now has to spend down those assets. So they have to spend all those assets down before they can qualify for things like Social Security disability or Medicaid or any kind of state aid that is available to them if they didn't have the resources. If you place money off to the side into what's called a special needs trust, those assets would be supplementing what the state government provides, not giving it 100%. And all that money that you worked so hard and so tirelessly to provide for your family and to accumulate now has to go to pay for the medical bills, and they receive no additional assistance. They don't receive food stamps. They don't receive the Social Security. They don't receive the Medicaid assistance. So all those benefits that are available to most individuals, those are not available. We're still going through this today, and we're going to continue on. But if you have questions during this broadcast, and you want to ask your specific questions about this, today's topic, which is the state mandated will, you can call us at 618-217-1400. Again, it's 618-217-1400. Our phone lines are open, and we'll be hopeful to get to your call and see if we can't get an answer related to your question. You can also email us at radio@sivialaw.com, and it's radio@SIViaSinVictorIA law.com. We look forward to talking to you, but while we're waiting for those phone calls to come in, we want to take a moment to express our gratitude to our incredible sponsors who make Let the Record Show possible and support our mission of guiding you through life's transitions. Today, we'd like to thank Bridges Home Realty, Keystone Place at Magnolia Commons, and Absolute Health for their unwavering support. Bridges Home Realty is your go-to destination for a seamless and integrated home buying experience. They specialize in buying and selling single-family homes and offer expert senior living placement assistance. For more information on Bridges Home Realty, you can visit them at www.bridgeshomerealty.com, or you can call Sarah Holscher. Sarah is a wonderful woman. She really takes the time with our individuals and really does a great job with selling homes and helping people through senior living placement. So if you need help trying to figure out where you want to go, or you have a parent that needs to figure out where they need to go into a senior living and what are the options and things that sort, call Sarah, and she will help you out. You can call her at 618-979-3602. Again, it's 618-979-3602. We also like to extend our appreciation to Keystone Place at Magnolia Commons, a retirement living community that is changing the perception of what a retirement community is. Keystone's communities are designed to evoke the feeling of home, providing compassionate support and comfort and privacy. With more than 40 communities across the country, Keystone Senior Living is committed to improving the lives of our cherished residents. To learn more about Keystone Place at Magnolia Commons, call 618-685-2259. Again, it's 618-685-2259. If you're looking for a good place, and you're over the age of 55, give them a call. They have amazing facility in Edwardsville, and it's just getting ready to be launched. And I took a tour the other day, and it is absolutely positively stunning in there, and what they're doing. It is not the old-fashioned nursing home and senior living that most people expect. So take a look at that. If you have questions, give them a call. But last but not least, we want to express our gratitude to Absolute Healthcare Services. As an Illinois licensed home service agency, they play a critical role in caring for seniors and bringing peace of mind to families in need of care for their loved ones. Choosing home care through Absolute Health can often be a more cost-effective and comfortable option compared to full-time nursing home care. For more information, call them at 618-466-1010. Again, it's 618-466-1010. Give them a call. They help you through, allow you to stay in your home as long as possible. So if you know of anybody that is in their home, they need a place to stay, or they want to stay in their home as long as possible, then give them a call, because that's so important to maintain you in your residence. If you don't want to live in a fantastic place like Keystone, call Absolute Healthcare Services. To our sponsors, we thank them for their commitment to making a positive impact in the lives of our listeners and the community. Your support helps us continue to bring valuable insights and expert advice to those navigating through life's transitions. So let's get started back. In the beginning of this episode, we talked about assets and how they're divided between your children and your spouse. We talked about bond for probate. We talked about children under the age of 18 receiving assets after the person is gone. And we're going to get started back. So welcome back. I'm Todd Sivia, your host and partner in navigating life's transitions at Sivia Law. We believe that every transition in life deserves careful consideration, planning, and that's what we're talking about. We left off talking about those people over the age of 18, and how they spend their money, and we talked about disabilities and things of that sort. But what about our kids under the age of 18? What happens to those children? And how does a state legislator dictate how that money is dealt with? So we talked about, probate, and we have to divide the estate between the spouse and the children, and the money under the age of 18. And who does divide the money? People that divide the money is what's called probate. So you go to court, you go through this process through the court system that divides the assets, kind of like the woman that had the inherited piece of land. She went through probate, and there was a court process. Court process is anywhere between 6 months to 2 years going through that probate process. And it was crazy. Those two kids were over the two kids that received the portion of the land were over the age of 18. So we didn't have to worry about it. But what if they were under the age of 18? What happens there? There's a couple parts of that process. So if the spouse is still, one of the spouses is still alive, they may, with permission of the court, continue on and continue to manage those assets. After, they still have to account for it and file pleadings with the court every year to let things get established. But because the child is under the age of 18, they can't inherit anything specifically into their name and make decisions about it. So what happens there? Well, the next part of the process is we may have to establish a guardianship. Through that, we have to file basically another case. So again, you're hiring an attorney, probably the same attorney, to handle the guardianship, and you have to go through a process. And by the way, you have to hire a second attorney called a guardian. And under that guardian, that person is looking out and making sure that the other attorney is doing what they're supposed to be doing. So, and that's, again, state statute. So now we have two attorneys working on a case dealing with a minor in which their father or their mother passed away that handed them money. So now we have two court cases going that handle the minor's estate. The costs are going to be adding up, and they have to invest it. The money it's going to be hard for them to receive the money before the age of 18. So, they may, depending upon how old the person is at the time, maybe they're 14. And they have to go, if they want money for a car, they have to request the court to approve it. And it's very supervised. So you have to ask the court if you're for distributions. And every time something like that happens, you have to go and spend the money on attorneys to ensure that all of that is established. So, it's very, very monotonous. But guess what? because you don't have a will, you don't have anything designated on where that money goes, but who's going to take care of those children? 99% of the time, if the spouse is still alive, the courts are not going to determine that the other spouse can't handle that. But what if both spouses have passed and there's no will and there's no direction with regards to guardians? Who's going to handle that? That's a good question. That's definitely a good question, because with regards to that, the person that gets to fight, and it becomes a fight over who gets to manage those children. That's probably the biggest fight that I see when people come into my office talking about guardianships. A lot of people procrastinate with regards to going through and listening to going through an estate planning process is because they don't want to, because they can't agree upon the guardian. And that is usually the holdback. Usually after the last child turns age 18, they come into the office and say, okay, well, we've decided that we don't have to make the decision of who manages our minor children under the age of 18. Now we can sit down and talk about estate planning. Well, the problem is you just left open a big door, and that big door is a big fight between family members, especially if both spouses have mother-in-laws, and those mother-in-laws and the father-in-laws want to see the children. And they feel obligated and morally obligated to want to take care of their grandchildren. Well, now it becomes a fight. It becomes a fight over who is the guardian over those children. And maybe it's a cousin, maybe it's anybody. It provides the opportunity for a lot of people to fight and litigate over who's the best parent or who's the best person that is going to take care of these children, and what degree of relationship. So after you're gone, you provided them a lot of litigation associated with it because you put off the opportunity to set up your estate. And that's huge. There's two times when people get emotional that I found through practicing law. And it's usually family law, so dealing with a divorce, which is emotional. And then probate, fighting over things at the time of death. Even with the best laid plans, there is always some kind of emotional battle because let's be honest, it's very emotional. You just lost somebody that you loved and cared for, and that person didn't have a plan, didn't establish a plan, and now you have to go through this litigation and hire attorneys, and instead of listening and being non-emotional about it, you bring in the emotions because you have this hole in your heart, and this hole in the heart that you once had is now gone, is still there because your child may have passed, or maybe your brother and sister passed, whatever it may be. But now you've let it to be litigated. But if nobody claims it, if nobody claims the children, you're leaving the children to the state. Maybe you wanted a non-family member to take it over. Maybe you don't have family members that would be responsible to take over your children. And maybe a good friend would be your better option. Those are all options that are associated with it, and it would be nice to have that plan established. But if you don't have a plan, state legislature has a plan for you, and that is your kids get to go and be dealt with by the state. So all those things are important, and you've got to report, and you've got to deal with the guardianship. But here's an interesting one. Let's tell you a little quick story. Say husband and wife have been married for 25 years. Husband passes away because statistically guys will pass away, and wife is there. Wife's a pretty good catch. 25 years, that may put them at maybe 45, maybe 50. They've got, they're no elder, and they could get married again. Maybe 5 years later, and they inherited. They received all your assets. Now all your assets are in wife's names. Wife now gets married to husband. And what if wife passes away? What happens? So maybe she has a will that passes all of her assets over to new husband because she wants to take care of that new husband. Now, new husband has all the assets that the original husband and wife established. And does that new husband have an obligation to deal with the original kids? They don't. They don't have any obligation to support or provide any kind of financial needs of the children of the original marriage. All the money could be handed off to his family and his situation. So, how do you deal with that? And there's ways of dealing with that, ways of making sure that the kids are protected and even the new spouse is protected, vice versa. So, I've seen situations where you have a new marriage and a new relationship, and all those assets are spent by the new spouse. So blended families are great opportunities to do planning, and you never know what is going to happen in those circumstances. But blended families definitely need to have a plan and ensure that you know how that's going to happen. But the state, there's nothing in the state statutes that says the original kids should receive anything. It should be passed off as per the statute. So that new spouse gets to receive, again, half of the assets, and the other half may go to the children if they don't have a will. So retirement accounts, if you've got a retirement account and you have no one named as a beneficiary, or you don't, and it falls back to the estate, anything that's in a retirement account is usually put in pre-tax. So if you put the money in pre-tax, it becomes taxable. So if it's taxable, there is definitely some issues with regards to that. So all that money could be taxed at the highest tax rate, which may be the estate rate. So you're paying 30 to 40% in taxes associated with an inheritance of that money because you don't have a beneficiary on your retirement account. And a lot of people have those tax accounts that are available, and especially these days, back in the 70s and, if 60s, 70s, and 80s, pensions were big. And there wasn't anything that really came back. And there was no 401ks, there was no 403bs. It wasn't very relevant or prevalent associated with it. Over time, it has definitely become more and more relevant and become more of an issue. So making sure that you have a beneficiary on your retirement account. But again, there's no restrictions. So any beneficiary that receives that money may take all of that money out at the highest tax rate. And if they received $100,000, or say you have $1 million sitting in your retirement account, and you've been very studious about preserving your assets, making sure that you have enough money for retirement, and all of that money, but you weren't studious and put a beneficiary on your retirement account. It all falls back to the estate and becomes taxable immediately. And you don't get some of the tax breaks associated with it. So you're going to, on that $1 million, you're going to pay 40% in taxes. So $400,000 goes out the door based upon that. Guns. Especially these days with guns, the state legislature just passed a bill with regards to AR-15s and some other rifles, pistols, whatever you want to call them. That's for debate for the state legislature and the Supreme Court and all the other district courts that are litigating this case right now. But guns, a lot of people don't realize that firearms, if a family has a firearm, and in the state of Illinois, you are required to have a FOID card, a firearm identification card on you, and possess that in order to have a firearm. And if you don't have that, then there are problems. So, say husband and wife pass away, and they've got, say they have some of these statutory firearms that are concerning. Those statutory firearms now have to be, if they aren't registered, that could be a felony because you're in possession. But maybe they're Illinois residents and they don't have a FOID card, and they take possession of a firearm. Or your executor takes possession of a firearm and they don't have a FOID card. That is an accident, what we call an accidental felony. So if they get pulled over or receive that firearm, and they don't have that FOID card, and we don't do a transition plan for firearms, they could accidentally get and be given not only an inheritance, but also a felony. So it's always important for people with firearms to have a plan of action. So let's talk about businesses. That's a definitely interesting topic. If you have a business and you don't have a will, you don't have an estate plan, and it all goes back to the state, guess what? Guess who gets to make the decisions? The man or woman in the black robe. It's so. I love judges, but I really don't want a judge to be the arbitrator and the decision maker on my business. Most of them, they're working for the state. Some of them have businesses off to the side, some of them don't, and running a business is kind of intricate. And you've got employees that you're trying to manage. You've got vendors and customers and all this. And you have to have a judge rule on who gets to manage and run the company. If you don't have an estate plan, the judge is the one that makes those decision making, and making financial decisions sometimes is that judge. So, it's important, and that's what the rules say based upon the state legislature. So you got, employees fighting for ownership. You got beneficiaries fighting for ownership, and it's definitely, maybe two of the family members are working for the business, and the third one hasn't been, and the third one wants to be involved in the business. Well, now you've established it, and now the third one does have the opportunity to fight for control of the company. But also, because you allow for the state legislator to plan your estate, we get into a situation where the estate can be contested. And I really like my clients, and we don't mind litigating. We don't mind litigating cases, but in probate, if we have a clear laid out plan for everything and a no contest clause in their estate, then at any point in time, it is ripe for contesting. And we've had cases that they've spent thousands upon thousands of dollars associated with attorney's fees and litigating probate cases. Not just a couple $1,000, but we're talking hundreds of thousands of dollars litigating over a case that really shouldn't have been litigated in the first place. There's no sense in it. And, I don't mind making money, but if we can cut off some of the issues, it's very, very important. And it's very, very important for us to not litigate those cases if we can do so. And we can do that by having some kind of estate plan and not following the rules of the state legislator that they've established for us. So today, if you have questions with regards to your estate, or if you want to pose a theme or an idea for our radio show, please give us a call at 618-217-1400. Again, it's 618-217-1400. We would love your feedback with regards to this program. That way we can make things better. You can also send us an email. Send us an email at radio@sivialaw.com. Again, it's radio@sivialaw.com. We want to, again, thank our sponsors, Bridges Home Realty, Keystone Place at Magnolia Commons, and Absolute Healthcare Services for all of their support with regards to this program. And we want to thank you for joining us today on Let the Record Show. I hope you found our discussion on estate planning and your will based upon the state statute empowering and enlightening. And if you want to go onto our resources page at sivialaw.com, again, you can find that John Doe will and look at it and see what the state legislator has written for you. So go on that resource page and download that will. It's pretty entertaining. So go and check that out. But remember, at Sivia Law, we are here to guide you through life's transitions, no matter how complex they may seem. If today's show has inspired you to take action, secure your future, don't hesitate. Reach out to our radio show at 618-217-1400 or email us at radio@sivialaw.com. As a special offer for our dedicated listeners, the first 5 callers will receive a 30-minute complimentary consultation with our experienced team, valued at over $150. Stay tuned for more episodes as we continue to explore the topics that matter most to you. Until next time, take care, and remember, your future's in your hands. Let the record show that we're here to help you in every step of the way. My name is Todd Sivia, and I appreciate your time.